Welcome to YCOB Entertainment. This analysis examines the dramatic conclusion of the state's case and the subsequent procedural challenge mounted by the defense in the high-profile Senso Maiwa trial on the 24th of July, 2025. The proceedings saw the state formally close its case after 3 years of presenting evidence, a milestone immediately overshadowed by urgent submissions from the defense. These submissions highlighted significant evidentiary and procedural deficiencies, including the failure to authenticate a crucial piece of visual evidence, the ENCA video clip, Exhibit 8, and the prosecution's ongoing inability to produce official motor vehicle movement records related to the accused's arrests. Faced with these shortcomings, the state conceded all uncalled witnesses to the defense. In response, the defense indicated its intention to file a Section 174 application for discharge, arguing that the state's evidence is insufficient for any reasonable court to convict. The matter was then adjourned to a provisional date, pending approval of funding from Legal Aid South Africa for this application. 1. Inconsistencies regarding timeliness and court authority. Points of exposure. Systemic failure to produce accused. The judge explicitly states this has happened for 2.5 years. Accused number 1 will either not be here 2 or 3 or whatever. Judge's intervention versus jurisdiction. The judge repeatedly asserts, I don't have the authority to regulate your area, but then uses inherent jurisdiction to make the order transferring accused number 5, Mr. Ntuli, to a different facility purely to force timeliness. This highlights the state's failure to manage its own process, forcing the court to act administratively. High-level apology. The deputy commissioner, a very senior official, apologizes and puts his head on the block to guarantee future timeliness. This serves as a public admission of prior systemic failure. Analysis of timeliness and court authority. This segment immediately exposes a critical, 2.5-year systemic failure by the state and its Correctional Services Department to fulfill the most basic logistical requirement of a criminal trial, ensuring the accused are present on time. The judge, Judge Ratha, clearly articulates his exasperation, recounting a history of delays that forced him to intervene. He states, accused number 1 will either not be here 2 or 3 or whatever, confirming the problem is not isolated but a continuous, disruptive pattern that paralyzes the court. This persistent inability to manage the movement of the accused fundamentally undermines the state's professionalism and efficiency. The exposure is magnified by Judge Ratha's defense of his own judicial action, the transfer order, which he admits falls outside his normal authority, stating, I don't have the authority to regulate your area. He justifies this extraordinary intervention by citing his inherent jurisdiction and the imperative to stop the constitutional rights of the accused from being violated by the state's delays. This maneuver provides a powerful narrative point for the defense, advm nisi, as it frames the court itself being forced to act against the state's mismanagement simply to move the trial forward. The defense can argue that a state struggling to transport prisoners reliably is one whose entire investigation and case should be viewed with skepticism. The presence of the senior-most prison official, the deputy commissioner and area commissioner, is a striking admission of institutional failure. His apology, my presence here my lord, demonstrate that the matter has been escalated at the high level, and his dramatic undertaking to put my head on the block to ensure future timeliness is a public, on-record concession of the department's prior negligence. This admission can be leveraged by the defense as evidence that the state's case has been continually hampered and prolonged by poor logistics, further reinforcing the argument that the accused's constitutional right to an expedited trial has been violated. The judge's repeated insistence that he is a very easy man and a disciple of Nelson Mandela who simply wants to start on time contrasts sharply with the chaos and delays reported. While intended to convey impartiality and patience, it serves to highlight the extreme degree of provocation required for the judge to issue such a disruptive order as transferring an accused. This narrative is valuable because it shows the judge was reluctant to interfere but was ultimately compelled by the Correctional Service's gross negligence. Furthermore, the judge confirms the severity of the situation by mentioning that the JP, Judge President, and the Chief Justice are on my back because they've never seen a case take so long. This statement elevates the issue from a procedural snag to a national crisis of judicial management, directly attributable to the failures of the state to facilitate the trial. The defense can use this high-level concern to argue that the institutional pressure on the court might compromise the fairness of the proceedings, although the judge insists he is only focused on timeliness. In summary, this entire exchange acts as a judicial inquiry into the state's logistical competence. The judge's reluctant intervention, the commissioner's high-level admission of failure, and the explicit linking of delays to constitutional right violations all provide ADV Mnissi and the defense team with powerful, recorded material. It shifts the narrative focus, however briefly, from the guilt of the accused to the fundamental unreliability and chronic inefficiency of the state institution supporting the prosecution, which may ultimately factor into the court's overall assessment of the state's ability to prove its case beyond a reasonable doubt. 2. Contradictory testimony and false information. Points of exposure. Accusation of lies. The area commissioner alleges that accused number 5, Mr. Ntuli, was afforded opportunity to present false information to the judge. Procedural impropriety. The commissioner claims Mr. Ntuli gave testimony, and the correctional services witness, Mr. Kabanu, was not in a better position to respond to other questions because he was the receiving person after the cell phone was found. The correct person who knew the facts was Mr. Madola, who was at Maxima. Dispute over security classification. The judge asks the correctional services witness to confirm the status of the accused. Is he classified in what status as what? Maximum for maximum. The judge then confirms, and then look up is at maximum, trying to establish the prisons were comparable to avoid disrupting security protocols. Analysis of contradictory testimony and false information. This section presents a direct and serious exposure for the state through the area commissioner's sensational and unverified claim that accused number 5, Fusokul Ntuli, provided false information to the judge. While the nature of this alleged lie is not detailed in the transcript, the mere on-record accusation by a senior state official is damaging. The defense can argue that this is a retaliatory move, a senior manager attempting to discredit an accused person for successfully exposing the correctional facility's operational issues and forcing a disruptive court order. This attempt to paint Mr. Ntuli as an untruthful witness can be spun by ADV Mnissi as evidence of state bias and victimization against the accused, especially since the alleged lie relates to prison conditions, not the murder charge itself. Furthermore, the commissioner points to a severe procedural failure in the state's own evidence presentation during the prior day's hearing. He claims that Mr. Kabanu, the official who testified, was not in a better position to respond because he was the wrong person. He was the receiving official, not the one present when the alleged cell phone was found. The commissioner asserts that the person who truly knows the facts appropriately is Mr. Madola and his team at Maxima. This internal critique publicly exposes a gross negligence in trial preparation. The state brought a key witness who was demonstrably ill-informed and unable to withstand cross-examination, allowing the accused's version to prevail unchallenged. This mistake, presenting an unprepared or secondary witness, is a major vulnerability in the state's armor, even if it pertains only to the peripheral issue of prison conduct. ADV Mnissi can effectively argue that if the state cannot manage to bring the correct, knowledgeable witness for a simple internal dispute, their preparation and diligence for the complex murder trial must be equally flawed. It raises the broader question of whether the prosecutor, ADV Beloyi, adequately vetted the witness's knowledge before calling him to the stand. The commissioner's explanation that his facility, Kosimbaruru, is where everyone that is giving the whole country a problem is brought, establishes the extreme high-security environment from which the accused is drawn. When combined with the subsequent argument that the transfer order is disempowering the facility, it frames the prison officials as being more concerned with maintaining their internal authority and security protocols than facilitating the court process. This admission suggests that the prison authorities may view the court's process as a lower priority than their own internal management of high-profile, high-risk inmates. The dispute over the accused's security classification provides a factual inconsistency. The judge is trying to confirm that the accused is classified for maximum security and that the new facility, LOC, is also maximum to ensure security is not compromised. However, the commissioner's overall distress and the need to appeal the order suggest that, in their view, Kosimbaruru offers a higher level of control or specialized management than the alternative. This implies that the facilities are not equivalent in status or security utility, contradicting the judge's initial understanding and highlighting a potential security risk created by the transfer, further showing the lack of coordination between the judicial and correctional arms of the state. Collectively, this section exposes the state to accusations of vindictiveness through the alleged lie, poor evidentiary preparation, through the wrong witness, and a fundamental disagreement between its correctional arm and the presiding judge over security measures. This can be strategically used by the defense to paint a picture of a disjointed, poorly coordinated state machinery that is sacrificing procedural fairness and diligence in its haste to conclude a long and high-pressure trial. 3. State's threat of appeal and forced compromise. Points of exposure. Threat to delay. The area commissioner states they are forced to apply to appeal that order, which will also cause this court a delay. Judge's recall offer. The judge directly offers to recall the order, if the commissioner provides a satisfactory assurance of punctuality. Legal standing. The defense advocate, ADV Nisi, argues the order cannot be rescinded, despite the commissioner's undertaking. Analysis of state's threat of appeal and forced compromise. The third segment culminates in a tense confrontation where the state's correctional arm uses the threat of further, self-inflicted delay as leverage against the judicial order. The area commissioner explicitly states that if the transfer order is not overturned, they are forced to apply to appeal that order, which will also cause this court a delay. This is a profound exposure for the state. A senior official is effectively threatening to hijack the trial's timeline, deliberately creating a setback in the interest of internal departmental policy. ADV Beloyi, the prosecutor, remained silent during this exchange, allowing the correctional services to publicly hold the trial hostage, which undermines the state's stated commitment to a speedy resolution. This threat forces the Judge Ratha, into a direct and unprecedented negotiation. His response, that he can recall the order, if he is given the satisfaction and the official order that the accused will come on time, reveals the extraordinary extent to which the judiciary is compromising its authority. The judge is essentially trading an administrative order made under inherent jurisdiction for a guarantee of logistical competence. This compromise confirms that the state's logistical incompetence is the primary driver of judicial decision-making, overpowering even security classifications and internal departmental wishes. The legal complexity introduced by the defense advocate, ADV Nisi, who correctly argues that the order cannot be rescinded or revoked, after being granted, highlights the precariousness of the judge's offer. If the judge were to recall a legally binding order based merely on a verbal undertaking, it could create grounds for further appeal on procedural grounds. ADV Nisi's timely intervention. I submit with due respect that the court order has been granted and my lord, it cannot be resigned, serves to protect the defense's interests by ensuring that a high-level verbal guarantee doesn't completely erase a favorable judicial finding without a formal, legally sound process. The commissioner's acceptance of the compromise, my lord, I put my head on the block. I will ensure that they are here before 10. Is a critical point of record. This shifts the entire burden of future delays onto the correctional services. Any subsequent tardiness can now be directly framed by ADV Nisi not just as negligence, but as a direct violation of a solemn, high-level undertaking made to the court, further damaging the state's credibility and potentially inviting judicial sanction or more radical interventions from Judge Ratha. This section thus serves as an extraordinary exposé of the power dynamic between the court and the correctional services. The correctional authority is revealed to be willing to use the constitutional rights of the accused as a bargaining chip, while the judge is willing to retract his own order to avoid further systemic delay. The defense is strategically positioned to benefit from this high-wire act, using every subsequent failure to demonstrate the systemic flaws and lack of cohesion within the entire prosecution apparatus. The judge concludes this section by reiterating the high-level pressure from the Chief Justice, emphasizing that his sole motivation is to stop this first experience of such long delays in his 55-year career. This closing statement reinforces the notion that the state is under a judicial and political spotlight, and that the proceedings are being driven more by the need to resolve logistical failures than to proceed efficiently with the evidence, a theme the defense can exploit to full effect. 4. Defense argument on constitutional rights and concentration. Points of exposure. Accused's loss of concentration. The defense lawyer, ADV Nisi, argues that the ongoing fight between the two, the department and the inmate, has a negative impact towards Mr. Nchuli's concentration and his ability to understand the proceedings. The undignified treatment. ADV Nisi relays the accused's perspective, stating the delays are due to him venting out their frustration because they are being treated in a way that they are not supposed to be treated with, specifically calling the conditions at Kosimbaruru inhuman and undignified. Critical stage of trial, ADV. Mnissi emphasizes that the court is towards the end of the state case, now approaching the defense case, making the accused's full concentration essential. Analysis of defense argument on constitutional rights and concentration. The defense advocate, ADV Mnissi, strategically elevates the transfer issue from a mere logistical inconvenience to a matter of fundamental constitutional rights and trial fairness. His submission directly links the Correctional Service's actions, or rather, their alleged mistreatment of the inmates, to the accused's cognitive state. By arguing that the fight between the two has a negative impact towards Mr. Nchuli's concentration, he is laying a foundation to challenge the fairness of the proceedings should Mr. Nchuli be unable to effectively consult or provide instructions at this critical juncture. This is a powerful, protective move designed to safeguard the integrity of the forthcoming defense case. The revelation of the accused's motivation for the delays further exposes the state's administrative failures. ADV Mnissi explains that the late arrivals were not arbitrary but were the accused venting out their frustration against conditions that are inhuman and undignified at Kosimbaruru. This is a serious, on-record accusation of prisoner mistreatment that suggests the state's correctional facilities are contributing directly to the disruption of justice. While the judge remains neutral on the veracity of these claims, the fact that this perceived mistreatment has been confirmed as the root cause of the scheduling chaos is a major weakness for the prosecution, ADV Abaloyi, and the state's integrity. Furthermore, ADV Mnissi uses the critical stage of the trial as a strong argument against recalling the transfer order. He states the court is towards the end of the state case, now approaching the defense case. This timing is crucial. As the trial moves into the defense's portion, Mr. Nchuli's full and unfettered concentration becomes non-negotiable for a fair hearing. The advocate is thus implicitly arguing that the judge must prioritize the constitutional right to a fair trial over the bureaucratic convenience of the correctional services, making the transfer order, which restored order, the only constitutional option. The advocate's submission transforms the judge's administrative order into a judicial measure aimed at preventing a mistrial. By emphasizing the inhuman conditions and the resulting inability to concentrate, the defense provides the judge with a justifiable, constitutional basis for the order, shifting the burden of appeal entirely onto the correctional services. This move expertly shields Judge Ratha from the accusation that he is merely interfering in administrative matters, instead affirming that his action was a necessary remedy for a state-created breach of an accused's rights. This section reinforces the theme of the state's fragmented operations. The alleged actions of the correctional services are directly undermining the work of the prosecution and the smooth running of the court, giving the defense significant material. ADV Mnissi leveraged this division to his client's benefit, painting a clear picture: the state's own agents are the source of the delays and the threat to Mr. Nchuli's right to a fair trial. In conclusion, this exchange solidifies the transfer order as a necessary defense against the state's institutional failure, framed entirely around protecting Mr. Nchuli's fundamental right to concentrate and participate in his own defense at a pivotal stage of the trial. 5. Legal authority of the judge versus locus standi of the department. Points of exposure. Section 173 of the Constitution, the defense lawyer cites this section to affirm the court's inherent power to regulate its own processes. Lack of legal standing. Locus standi. ADV Mnissi directly challenges the Commissioner's presence and manner of objection, stating, "You don't have locus standi to challenge the decision of the court, the manner in which you are doing it now. This is totally irregular." Refusal to meet in chambers. ADV the Baloyi, the prosecutor, and ADV Mnissi both confirmed they refused to meet the correctional services officials in the judge's chambers, citing improper legal procedure. The functus officio principle. ADV Baloyi introduces this legal principle, arguing the judge is now functus officio, having discharged his duty, and cannot revisit the order himself unless formally challenged. Analysis of legal authority and locus standi. The defense counsel, ADV Mnissi, and prosecutor, ADV Baloyi, join forces in an unusual alliance to staunchly defend the integrity of the judicial process against the informal and legally unsound challenges posed by the Correctional Services Commissioner. ADV Mnissi cites Section 173 of the Constitution, which grants the court inherent power to regulate its own processes, thereby providing a powerful, constitutional pillar for Judge Ratha's decision. This legal foundation effectively neuters the Commissioner's administrative objections, affirming that the judge's order was a constitutionally sound exercise of judicial authority, not an arbitrary act of interference. A significant exposure for the state's correctional arm is ADV's direct, public challenge to the Commissioner's legal standing, locus standi. By stating that the Commissioner has no locus standi to challenge the order in this manner and that his action is totally irregular, the defense advocate highlights the state official's blatant disregard for established legal procedure. This public rebuke of a high-ranking official's conduct in open court is a powerful moment that firmly establishes the supremacy of judicial authority over administrative convenience and incompetence. It suggests that the Commissioner, despite his rank, was acting outside his legal mandate and attempting to influence the court through inappropriate channels. This exposure is compounded by both advocates confirming they refuse to meet the correctional services officials in chambers to discuss the order. ADV Beloy notes, "I'm not going to see the court in chambers because they've got a legal person, she should know the law." This unified refusal by opposing counsel, the prosecution, and the defense, to engage in an irregular, out-of-court procedure demonstrates the systemic legal breach attempted by the correctional services. It suggests that the officials knew they lacked the legal grounds to formally challenge the order but attempted an informal, high-level negotiation anyway, further damaging their institutional integrity. Crucially, the prosecutor, ADV Beloy, introduces the functus officio principle, a Latin term meaning having discharged his duty. He argues that once Judge Ratha made the court order, he cannot go back and revisit that court order himself. This submission, coming from the state's prosecutor, is a powerful argument against his own institutional colleague, the Commissioner, whose request for a recall is now formally deemed legally impossible by the state's own lawyer. ADV Beloy is effectively telling the Commissioner that the only proper recourse is a formal legal application for review or appeal, not an informal plea. The overall legal alignment of the two advocates against the Commissioner's request isolates the correctional services and reveals their lack of respect for judicial procedures. The Commissioner is left with a single, clear path: either formally appeal the order, thereby delaying the trial, or uphold his promise of punctuality. The judge's final decision to leave the order as it stands is thus legally protected by Section 173 and the functus officio principle, entirely vindicating the court's action and putting the onus back on the correctional services to follow the law. 6. The Commissioner's evasion and the judge's final decision. Points of exposure. Evasion of the dispute. The Commissioner retracts the claim of a fight between the department and the inmate, now claiming there's no such. He then immediately contradicts this by asserting that source of the problem still remains there and blames the lack of discipline of these inmates. The Commissioner's locus poenitentii. Despite the overwhelming legal submissions, the Commissioner maintains his commitment. "I'm still making a commitment, my lord, that coming to court will not be a problem." Judge's final stand. Judge Ratha stands firm, leaving the order in place but granting the Commissioner the legal right to apply for a recession. "I'm going to leave the order as it stands." You can bring an application for recession. Okay. Analysis of the Commissioner's evasion and the judge's final decision. In this final exchange, the Correctional Services Commissioner attempts to evade responsibility for the underlying conflict that led to the transfer order. He first attempts to backtrack on the narrative of conflict, stating, "There is a dispute and I don't want to know about the dispute, there's no such fight between the department and the inmate." However, this is instantly nullified by his follow-up statement: the source of the problem still remains there, and his assertion that the true issue is the lack of discipline of these inmates and their shenanigans. This is a clear internal contradiction. He denies a fight but confirms a deep-seated behavioral and disciplinary conflict, attempting to shift the blame entirely to the accused, including Mr. Ntuli. This evasiveness, recorded in open court, further erodes the credibility of the state's witnesses from the correctional services. The Commissioner's statement that the inmate's behavior is the one that is impacting all that, the delays, provides a new line of attack for the defense, that the state is operating under the false premise that the accused are willfully being difficult, ignoring the defense's earlier claims of inhuman and undignified treatment which sparked the alleged indiscipline. The Commissioner's attempt to minimize the dispute is a clear exposure, showing that he is more concerned with protecting his department's image than honestly resolving the court's scheduling problems. Despite the legal and procedural barrage, the Commissioner maintains his only valuable contribution, his commitment to punctuality. This irrevocable promise, "I'm still making a commitment, my lord, that coming to court will not be a problem," is now his department's only saving grace. It serves as a permanent, high-level assurance to the court, making any future delay a direct personal and institutional failure. This promise is, therefore, the most significant gain for the court. Judge Ratha's final decision is a masterclass in judicial balancing. By deciding to leave the order as it stands, he adheres to the functus officio principle and the constitutional mandate, upholding the integrity of his previous ruling. However, by adding the caveat, "You can bring an application for recession," he respects the Commissioner's position and legal rights, avoiding a personal confrontation while forcing the correctional services to pursue a formal, legal path if they wish to challenge the order. This decisive action confirms the court's authority and ends the informal negotiation decisively. The judge's final remarks about the ANC's PAC split and Nelson Mandela are an explicit plea for common sense and avoiding ego-driven conflict. He likens the current situation to historical, intractable issues that were solved by talking, not fighting, concluding, "It's just functionality of reason, that's all." This message is directed squarely at the correctional services, urging them to prioritize the smooth running of the trial over internal departmental politics and ego, concluding the segment with a powerful judicial call for professionalism and cooperation. 7. State case closure and procedural duplications. Points of exposure. Formal closure. The state formally closes its case, noting it took precisely 3 years since they started leading evidence. Exhibit duplication renaming. The prosecutor, ADV Beloye, corrects a duplication. Exhibit J, Warrant Officer Steenkamp's affidavit, and another exhibit were the same, leading to the second exhibit, Forensic Pathology Officer Makwana's statement, being renamed Exhibit K. This required an amendment to the list of admissions. Typing error and unresolved death certificate. ADV Beloye notes a typing error and references the death certificate of a Mr. Thabam Malini, allegedly at the garage, which was not formally handed up but was referred to in evidence. The judge asks if the inquest is settled, noting the cause of death is under investigation. Analysis of state case closure and procedural duplications. The formal closure of the state's case, announced after precisely 3 years of leading evidence, provides the most significant exposure point of this segment. This time frame, 3 years, is a glaring testament to the prolonged and often chaotic nature of the trial, reinforcing the judge's earlier frustrations and validating the defense's arguments about the violation of the accused's right to an expedited trial. For the defense, this figure crystallizes the institutional delay, a powerful narrative tool that can be used to question the state's overall competence and commitment to a fair and timely process. The prosecutor, ADV Beloye, had to spend time correcting procedural and exhibit-related errors even at this late stage of closing the case. The necessary renaming of an exhibit and the amendment of the list of admissions due to a duplication underscores a persistent lack of diligence in the state's administrative and document management processes. While seemingly minor, this repeated need for corrections in open court suggests that the prosecution's case documentation is messy and prone to error. The defense, ADV Mnissi and ADV Beloye, can use this pattern to argue that if the state cannot accurately catalogue its evidence, the reliability of the evidence itself must be called into question. A more serious procedural flaw involves the death certificate of Mr. Thabam Malini. ADV Beloye confirms this document, which was referenced in Warrant Officer Steenkamp's report, and is relevant because Malini was allegedly at the garage, was not formally handed up as an exhibit. Introducing crucial, case-relevant information without proper formalization, only for it to be discovered and corrected at the closing stage, is a significant breach of procedural integrity. It exposes a haphazard approach to admitting evidence, risking the potential later exclusion of the evidence or a legal challenge to any finding based on unproven documentation. The judge's immediate query about Mr. Malini's death certificate, asking if the inquest is settled and noting the cause of death is under investigation, introduces a disturbing unresolved point of fact into the record. This suggests that a key potential witness or person of interest relevant to the state's own expert report, Steenkamp's, died under circumstances that are still legally unresolved. The defense can use this information to argue that the state's investigation into the periphery of the murder, including those allegedly present at the scene, was incomplete, unreliable, or perhaps obscured by a separate, unresolved legal matter. Furthermore, the extensive list of exhibit corrections and updates, including Exhibit Z, 2 aerial photos, and Exhibit DD4A and B photo comparisons and extracts of downloads, showcases the sheer volume and complexity of the electronic and visual evidence that the state relied upon. The need to formally admit these items belatedly, sometimes after the witnesses had already testified, suggests an ad hoc approach to presenting evidence, where documentation trails the testimony, not the other way around. In closing, the state's final act in leading evidence is marred by administrative cleanup and a procedural stumble regarding a key exhibit and an unresolved death. This provides the defense with concrete evidence of the trial's inefficiency and the prosecution's imperfect handling of its documentation, allowing ADVA Nissi to argue that the closure of the case is more an act of exhaustion than a completion of a perfectly prepared legal submission. 8. Failure to authenticate the critical ENCA video clip. Points of exposure? Unauthenticated video. The defense counsel points out that the ENCA video clip, Exhibit 8, remains unauthenticated because Mr. John Bailey, news editor, is no longer testifying. Agreement not to testify, the state, NPA, and the South African National Editors Forum, SANEF, had an agreement that Mr. Bailey would not be forced to testify. Bailey's affidavit to knowledge, Mr. Bailey stated he was in China when the video was taken and does not know who took it or the final details and integrities, he only provided a copy of what was aired. Constitutional challenge avoided. The state avoided forcing Mr. Bailey to testify because he threatened to bring an urgent application challenging the legality of Section 205 of the Criminal Procedure Act regarding the subpoenaing of journalists. Alternative witness. The defense suggests the state could call Mr. Longway, who is depicted in the video, to authenticate it, but the state appears not amenable to follow that route. Analysis of failure to authenticate the critical ENCA video clip. The defense's submission regarding the unauthenticated ENCA video clip, Exhibit 8, constitutes a massive exposure for the state's case. This video, which potentially places an accused, Mr. Longway, at a certain location on a key date, is a critical piece of evidence. By failing to secure the testimony of Mr. John Bailey to authenticate it, the state has left a vital exhibit as unauthenticated and, in the defense's words, a pronoun non-existent, crypto. If the video is formally ruled inadmissible due to a lack of authentication, the state loses a significant piece of visual evidence that was intended to bolster their timeline. The circumstances surrounding Mr. Bailey's non-appearance are equally damaging. The state's decision to back down from forcing his testimony was due to an agreement with SANEF and the threat of an urgent constitutional application. This publicly exposes the state's fear of a legal challenge that would question the constitutionality of the Criminal Procedure Act Section 205 dealing with journalist subpoenas. The prosecution, ADV the Beloy, prioritized avoiding a potentially precedent-setting legal fight over securing critical evidence for the murder trial, suggesting a lack of confidence in their legal position against the media organization. The content of Mr. Bailey's intended testimony, as relayed by the defense, is also deeply problematic for the state. Bailey indicated he was in China when the video was taken and knew nothing of the final details and integrities. This means that even if he had testified, he could only authenticate that the copy was what ENCA aired, not the chain of custody, the time it was recorded, or who recorded it. This intrinsic lack of direct knowledge further highlights the state's weakness. They pursued a witness who was fundamentally unable to provide the necessary forensic authentication required to prove the video's reliability in court. The defense's suggestion of an alternative witness, Mr. Longway, who is depicted in the video and is alive, publicly exposes the state's selective prosecution strategy. By appearing not amenable to call a witness who has direct knowledge of the video's content, i.e., the person in the footage, the state reinforces the perception that it is avoiding witnesses who might introduce facts detrimental to their case. The defense cleverly implies that the state is deliberately keeping Mr. Longway off the stand to prevent full disclosure regarding the video's origin or context. In sum, the failure to authenticate this video is not just a procedural hiccup, it is a failure of evidence. It showcases the state's legal timidity, avoiding the constitutional challenge, and their poor strategic planning, pursuing a witness who lacked the necessary primary knowledge. The defense can now argue that the video must be disregarded, potentially creating a significant hole in the state's presentation of the events of October 27, 2014. 9. Failure to provide records on motor vehicle movement. Points of exposure. Motor vehicle records outstanding. A defense counsel states that an accused has been requesting that certain information, the records regarding the movement of the motor highs that were used on the day on which he got arrested, should be made available to him. Incomplete endeavors. The defense admits the state made some endeavors, but the explanation regarding a specific hardbody vehicle, which was allegedly involved in an accident where Mr. Mdluli, presumably, passed away, was only a partial explanation. Outstanding information. The request is for the records regarding the movement of the vehicles, implying an ongoing need for the official log or GPS data related to the accused's arrest. Analysis of failure to provide records on motor vehicle movement. The defense's final point of submission exposes a persistent and crucial information gap created by the state, the failure to provide complete motor vehicle movement records relating to the arrest of one of the accused. The request for these records is highly significant, as vehicle movement logs, like GPS data or logbook entries, are key to verifying or disputing the circumstances, time, and location of the arrest, which could be critical for an alibi defense or a challenge to the legality of the detention. The defense notes that while the state made some endeavors to address the request, these were insufficient. The specific reference to the hardbody vehicle being involved in an accident where an official, Mr. Mdluli, passed away is a complex and potentially distracting detail, but it does not absolve the state of providing the records of movement for all vehicles used during the arrest. The failure to provide complete, official logs leaves the defense without a crucial tool for forensic scrutiny, suggesting that the state is either incompetent in record keeping or deliberately withholding information that might contradict their version of the arrest. This omission directly impacts the accused's right to a full and fair defense. Without the official records of the arresting vehicle's movements, the defense cannot properly challenge the state's version of the arrest, a foundational event in the case. This gives the defense grounds to argue that the state is operating in bad faith by failing to comply with discovery requests and denying the accused access to material that could prove their innocence or challenge the state's evidence chain. The fact that this request remains an outstanding issue at the moment the state closes its case is a profound exposure of procedural failure. The state has essentially closed its case while a key piece of information requested by the defense, information that should be simple administrative data, has not been fully provided. This allows the defense to argue that the closure of the state's case is premature and that they were compelled to face a defense case without all the necessary discovery materials. This submission reinforces the theme of information control by the state. Just as the state controlled the authentication of the ENCA video, here they are controlling access to administrative records. The defense can leverage this pattern to suggest that the state is only providing information that supports its narrative, while information potentially helpful to the defense, like the exact timeline and route of the arresting officers, is withheld or obscured by complicated peripheral issues like the car accident. In conclusion, the failure to provide these movement records remains a glaring procedural deficit, seriously weakening the state's posture at the close of its case and providing the defense with a powerful argument regarding the violation of discovery and fair trial rights. 10. Persistent failure to disclose motor vehicle records. Points of exposure. Unexplained vehicles. The state still has no explanation or records for several police vehicles allegedly involved in the arrest, specifically the silver Qashqai driven by Mr. Gamani Singamani, Mr. Majidi. A Ford Ranger driven by Bongani Yend, a SAPS member. Contradictory AVL information. There are conflicting statements regarding AVL, automated vehicle location, records. The Golf 7 was not fitted with AVL. Kahulani Metro Police claimed their vehicles were not fitted with AVL in 2020, when the accused was arrested. This contradicts the testimony of a gentleman, Mr. Listenering, who said that yes they indeed fitted. Information in SAP's domain. The defense emphasizes that this is information in the domain of the South African Police Services, and they have no other avenue to request it, placing the onus entirely on the state. Analysis of persistent failure to disclose motor vehicle records. The defense's reiteration of the outstanding motor vehicle records exposes a systemic and egregious failure by the state to comply with basic discovery obligations, even after the case has been closed. The continued lack of explanation regarding the silver Qashqai and the Ford Ranger is particularly damaging. These vehicles, allegedly used in the arrest of an accused, are key to verifying the arrest timeline and process. The state's inability to account for its own operational assets suggests a severe breakdown in record-keeping or a deliberate reluctance to disclose evidence that could undermine the version of events provided by the arresting officers. The issue of the AVL tracking records further compromises the state's credibility. The defense highlights a direct contradiction between the official explanation from the Ekurhuleni Metro Police that vehicles were not AVL fitted in 2020 and the previous testimony of Mr. Listenering, who testified they were fitted. This conflict, which remains unresolved at the close of the state's case, suggests that the state's own internal records are unreliable and that witnesses may have offered conflicting or incorrect testimony under oath. This contradiction can be exploited by the defense to argue that the police evidence regarding the arrest details is fundamentally untrustworthy. The defense advocate underscores the crucial point that this information is in the domain of the South African Police Services. This emphasizes that the defense is not asking the state to do police work, but merely to provide internal, administrative documents that belong to the prosecution's own institutional apparatus. The state's failure to furnish these records, which should be readily accessible, amounts to a denial of a fair trial right, as the defense is being deprived of crucial evidence needed to challenge the circumstances of the accused's arrest, an essential component of the defense case. The identity of one of the drivers, Bongani Yend, being a member of the South African Police Services, SAPS, reinforces the fact that the vehicles were official police assets. The state's inability to track and disclose records for vehicles driven by its own members during an official operation is a profound administrative exposure, suggesting a pattern of unaccountability within the investigating team. In essence, the state is closing its case while knowingly withholding or failing to locate evidence that could be exculpatory or used for impeachment. This forces the accused to proceed with their defense case without full discovery, a situation which may later form the basis of a procedural appeal. The state's repeated failure to cure this defect, despite multiple requests, presents a serious procedural obstacle and damages the perception of the state's commitment to procedural fairness. 11. State's legal argument to save the unauthenticated video, Exhibit 8. Points of exposure. Reliance on real evidence. ADV Beloyi argues the video, Exhibit 8, should be admissible as real exhibit, or real evidence, which only requires relevance to be admitted, and the issue of authenticity weight can be argued at the end of the case. Relevance argument. ADV Beloyi claims the video is relevant because it deals with a proposition made by a former defense representative regarding Mr. Longway shooting himself in the leg during a struggle. The video, which depicts Mr. Longway, is intended to contradict this version. Hearsay condition not met. ADV Beloyi confirms the initial condition for the video's provisional admission, calling Mr. Bailey, is no longer possible. Conflicting legal precedent. ADV Beloyi quotes legal authority, Hoffman and Zeffert, SV Mumlaw, SV Beloyi, that distinguishes between admissibility, relevance, and weight, authentication. However, the case SV Mumlaw lists authentication methods, including calling the photographer or a person present, which the state failed to do. Analysis of state's legal argument to save the unauthenticated video, Exhibit 8. The prosecutor, ADV Beloyi, delivers a lengthy, academic argument to salvage the unauthenticated ENCA video clip, Exhibit 8, which the state desperately needs to counter a defense proposition. By arguing the video qualifies as real evidence, which only needs to pass the low hurdle of relevance for admissibility, ADV Beloyi attempts to circumvent the fact that the original condition for provisional admission, calling Mr. Bailey, was not met. This maneuver exposes the state's willingness to rely on legal technicality to admit evidence that is procedurally flawed, rather than conceding its evidentiary failure. The relevance argument is based on the claim that the video counters a proposition made by a now-late defense representative, that Mr. Longway accidentally shot himself in the leg. ADV Beloyi argues the video, which depicts Mr. Longway, is relevant to proving the state's timeline and disproving this self-shooting version. This argument is strong on relevance but exposes the procedural reliance on an unproven link. The relevance of the video is tied to the identity of the person depicted and the time the video was taken, both of which are contingent on proper authentication, the very thing the state has failed to secure. Despite his scholarly references, ADV Beloyi's argument relies on a conflation of admissibility and weight, which he himself attempts to deny. While the cases cited support the view that relevance is the threshold for admissibility, the authorities also clearly define how real evidence, like a video, must be authenticated to be admitted in the first place. The case SV Mumlaw lists 3 methods of verification, none of which the state successfully executed. They didn't call the photographer, a person present when recorded, or an expert on the equipment's operation. The investigating officer's identification of Mr. Longway only goes to weight, not to the integrity or origin of the video itself. The prosecutor's position is weakened by the fact that he has already confirmed the hearsay condition was not met. The video was only provisionally allowed subject to Mr. Bailey's testimony. Now that Bailey is unavailable, that condition is impossible to fulfill, creating a legal vacuum. Judge Ratha immediately highlights the final absurdity by interjecting, "The evidence of is that Bailey, is it before court?" Well, the evidence no it's not before, yeah. This confirms that all the preceding arguments and assumptions about what Mr. Bailey would have said are legally irrelevant, as his information is not on record. In summary, ADV Beloy's extensive legal submission, though highly technical, ultimately exposes the state's failure of proof on a key exhibit. By failing to secure the required testimony for authentication, the state has introduced a significant weakness into its case. The argument that the court should simply disregard the authentication failure at this stage is a plea for judicial leniency that can be vigorously challenged by the defense, who will rightly argue that a critical piece of evidence remains unproven and inadmissible. 12. Defense's application for options and state's premature closure. Points of exposure. Defense options. Now that the state has closed its case, the defense has options, including testifying or bringing an application for discharge under Section 174 of the Criminal Procedure Act. Accused number 1 and 3 consultation. Defense indicates they have consulted with Legal Aid South Africa on behalf of accused number 1, Muzi Sibia, and accused number 3, Mthobisi Mcube, suggesting these two may be taking a different procedural path from the other accused. State's response to closure. ADV Beloy confirms that the law dictates the defense must now present its case, offering various options. Analysis of defense's application for options and state's premature closure. The segment concludes with the procedural turning point of the trial, the state's formal closure of its case after 3 years, which now grants the defense their statutory options. This closure, coming amidst the 2 major unresolved procedural issues, unauthenticated video and outstanding vehicle records, allows the defense to pivot from challenging the state's conduct to challenging the state's evidence. The primary options now available are to proceed with leading evidence or to bring a Section 174 application for discharge, arguing that the state has failed to present prima facie evidence that a reasonable person could convict on. The brief consultation by the defense on behalf of accused number 1, Muzi Sibia, and accused number 3, Mthobisi Mcube, with Legal Aid South Africa suggests that the accused are now making strategic decisions regarding their individual cases. This hints at a potential divergence in defense strategies, where not all 5 accused may choose the same path. For instance, some may opt for the Section 174 application while others may proceed to testify. This strategic decision-making highlights the defense's focus on exploiting the weaknesses confirmed during the state's case, particularly the failures related to the arrest records and the video authentication. The prosecutor, ADV Beloy, acknowledges that the law dictates the turn of the defense, offering various options. This formal concession signifies the end of the state's control over the presentation of evidence and the start of the judicial assessment of its evidentiary totality. The 3-year duration of the state's case is the critical metric against which the sufficiency of the evidence will now be judged. The immediate transition to the defense's options, without any immediate judicial ruling on the outstanding legal and discovery issues, means that the Section 174 application, if brought, will be the first opportunity for the defense to formally catalogue and argue all the exposures, contradictions, and procedural failures, including the unauthenticated video and the missing vehicle records, as evidence that the state's case has collapsed. The state has closed its case, but the damage inflicted by its internal inconsistencies and procedural lapses remains ripe for a legal challenge. 13. State's concession of defense rights and witness availability. Points of exposure. Formal concession of witness availability. The prosecutor, ADV Beloy, formally confirms that any witnesses who is not called by the state is at the disposal of the defense. He adds, "We make them available to the disposal of the defense." Clarification on disputed exhibits. The judge and ADV Beloyi agree that the defense advocate, ADV Mnisi, is still entitled to argue the issue of the unauthenticated video clip, this video, and the outstanding vehicle records, Cast, Nation Kasai and the Apava are Mr. Bangani, at the end of the case. Liberty to subpoena. The judge confirms that the defense is at liberty to subpoena any witnesses to testify in their favor. Analysis of state's concession of defense rights and witness availability. The exchange begins with Judge Ratha and ADV Beloyi formally settling the procedural ground rules now that the state's case is closed. ADV Beloyi's official confirmation that all uncalled state witnesses are now at the disposal of the defense is a crucial, legally binding concession. This means the defense, ADV Mnisi, is now free to consult with and subpoena any of the witnesses listed in the state's documentation without requiring the state's permission. This effectively allows the defense to call adverse witnesses, those the state chose not to use, to introduce facts that may be detrimental to the prosecution's version, significantly broadening the defense's strategic options. Crucially, the judge allows ADV Mnisi to maintain the procedural fight over the unauthenticated video and the outstanding vehicle records. By stating that ADV Mnisi can argue at the end of it all around this video and the other issues, Judge Ratha confirms that the state's technical closing of its case does not absolve it of the procedural failures that occurred. This ensures that the defense can use the state's lapses, the unproven video and the missing vehicle records, as substantive arguments in the application for discharge or during the final argument, reinforcing the state's earlier systemic exposures. The judge's emphasis on the defense's liberty to subpoena any witnesses underscores the shift in the trial's burden and control. It reminds the state that the trial's progress is now contingent on the defense's preparations, including tracking down and securing testimony from individuals who were perhaps previously shielded by the state's control over its witness list. This is a powerful legal statement confirming the full rights of the accused to mount a vigorous defense. The entire exchange serves as a crucial procedural cleaning up exercise, confirming that the defense is fully aware of its rights and that the state has formally conceded its loss of control over witnesses. This clarity is essential before the defense can proceed to the next major step, the application for discharge. The state's only remaining function is reduced to cross-examining witnesses in an event that they will come to that level, marking a definitive end to the state's time for leading evidence. In summary, this section is a procedural triumph for the defense, solidifying their right to a comprehensive defense by securing access to all remaining witnesses and ensuring that the state's procedural failures remain active arguments in the case. 14. Defense application for Section 174 discharge and adjournment. Points of exposure. Instruction to bring application. The defense received instructions from their clients, at least accused 1 and 3, to bring a Section 174 application for discharge. Funding approval required. The application requires funding approval from Legal Aid South Africa, specifically its CMC, Case Management Committee or similar head committee. Adjournment requested. Due to the funding process, ADV Mnisi requested the matter be adjourned for nearly a week, up until August 7. Provisional date. The date of August 7 is a provisional date to decide whether or not to bring the application, pending the CMC's decision on August 6. Analysis of defense application for Section 174 discharge and adjournment. The central development of this segment is the formal declaration by ADV Mnisi of the defense's intent to bring an application for discharge in terms of Section 174 of the Criminal Procedure Act. This application is a direct and aggressive challenge to the sufficiency of the state's 3-year case, arguing that the evidence presented is so weak that no reasonable court could convict the accused, necessitating an immediate acquittal. This move directly leveraged all the systemic failures, contradictions, and evidentiary holes, like the unauthenticated video and missing records, that were exposed during the state's case. The procedural barrier that follows, the need for funding approval from Legal Aid South Africa's CMC, provides insight into the bureaucratic realities of a lengthy, high-profile trial. The defense is entirely dependent on external funding for this crucial, complex legal argument. This dependency necessitates a near week-long adjournment, from the current date, implied to be around the end of July early August, to August 7, simply to wait for the CMC's meeting on the 6th. This exposes the layer of financial bureaucracy that governs the defense of the accused, creating yet another delay in the proceedings, albeit one that is administrative, not operational. The date of August 7 is explicitly confirmed by all parties, the judge, ADV Abaloyi, and the other advocates, as a provisional date to decide whether or not to bring the application. This crucial qualification means the court is not adjourning to hear the Section 174 application, but merely to hear the result of the legal aid funding decision and the defense's final choice. This highlights the uncertainty that lingers over the trial's next phase, as the entire progression hinges on the financial decision of an external body. The judge's final order, remanding the matter to the 7th of August as a provisional date, formally legitimizes this necessary delay. The collective confirmation by all advocates and the judge of this date and its provisional nature ensures that all parties are aligned on the purpose and timing of the adjournment. The applause at the conclusion of the segment, likely from the gallery or the parties, reflects the relief that the state's challenging and prolonged case has finally reached a provisional conclusion and the proceedings have taken a definitive turn toward a legal challenge to its entirety.